Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Oxford University Press. It's a first-class book. Anybody involved in company law, whatever you want to call it today, corporate governance, it's about shareholders, it's about the way companies are run. The book is The Law of Majority Shareholder Power, Use and Abuse, now in a second edition. It's got some powerful people writing it. David Chivers, Queen's Counsel, Ben Shaw, Ceri Bryant, Queen's Counsel, and Chantelle, Staynings. This book is an important book, I think, for you if you're involved in company law. Or if you're a company secretary, I think you'll find this an important book. Again, many company secretaries are certainly legally qualified, or they hold academic legal qualifications. Let's have a look at the book first of all. Here it is, red cover at the front. It's only a small book. There's the front, there's the side, and then there's nothing on the back. The front cover there again, just to show you. It runs not to that many pages, to 250 odd pages. The actual index, which you can see there, it's much the house style of OUP all the way through. But it's paragraph numbering. It doesn't say so, but that's what it is. There's the index at the back. You can see the paragraph numbering is at the side, and of course there's a huge amount of detail in this. This is a book for practitioners, and I think very, very useful for anybody involved in giving advice on majority shareholder responsibilities. The foreword is always worth reading because it's updating the reader on what it is. It says the title of this book, now in its second edition, is deliberately provocative. By reversing the usual emphasis on the rights of minority shareholders, to majority shareholders, and so now read on. But it certainly gives you a lot of information. Anybody who's involved in company law will remember all the wonderful cases and all the other things that have happened. But this one, when it says provocative, it's really to say, look, this is the position you're in when you're actually in the majority, and that's coming from David Richards as Lord Justice Richards. There we go. And then after that, you've got the preface to the first edition by the two main authors in February 2008. Then you've got the 11 chapters. You can see they're listed. Offshore jurisdictions are covered right at the end, and there's some much more detailed contents there. And then after that, you've got a table of cases, quite a lot of cases. There's always a lot of case law. One of the nice things about company law is you've got so much by way of case law. Then you've got the legislation, and you've got UK, and you've got other jurisdictions as well, because there is overseas information. There's the list here of the authors. Ceri Bryant, her practice spans company law, corporate insolvency, financial law, and took silk in 2012. Then you've got Chivers, then Ben Shaw and Chantelle Staynings. Again, you've got a very useful, I'm just looking, I think they're all from Erskine Chambers. Let's just check, I think they are. So in fact it's a little bit of a Chambers outing, this one. Yes, they all appear to come from Erskine Chambers. So well done, Erskine Chambers. There's the introduction. And then you've got a little bit of paragraph numbering at the bottom there. The introduction again, setting the scene, if you like. What's good about OUP, and I have to say I always like commenting on this, they do have a nice little short index for each chapter, so you should be able to find things pretty easily. And then there's a chapter overview as well. As I say, it's not a big book, this one. So if you, depending on what you've got all the usual suspects here. For instance, Allen and Gold Reefs. You probably remember that if you're a student. I certainly do. So you've got all the basic case law, which is established, if you like, the common law principles, and then of course it's all linked together with, as is to be expected, all of the main legislation. Obviously the Companies Act itself dominates the list of legislation, which is bound to do. And they're just running through. You've got unfairness, their behaviour, basically the behaviour of majority shareholder power. It is given the subtitle of use and abuse, and I think that's important because when you're in a strong position, as you will be as a majority shareholder, obviously we have the issue of minority shareholder rights, and the fact that they do feel to be the underdogs, which of course they are, but there is always going to be the issue of how far can you go, what is reasonable, what is proportionate, and again, just looking at it from a general, if you like, common sense point of view about what should and should not be done, because there are certain types of behaviour which are completely unacceptable, but they still get away with it. And it's not just in this area, it's across the board. However, this book, I think, will be of help. Now, Elizabeth has done the majority of the work on this, and it's her title for the review, Majority Shareholders Have Their Rights Too, as minority shareholders should be aware. This book is applicable to both. Now, I think that's a useful word of warning right at the beginning, because as it says, Richard says this is very provocative, this title. But the fact of the matter is that if you are a minority shareholder, read this book too, because it gives you some indication of what that lot are getting up to. And you can see then how you might possibly be able to assert yourself, depending on what the issue is. Let me tell you a bit about the book. It's a book that both majority and minority shareholders and legal counsel should refer to whenever the need arises, which it often does. It does make sense then that minority shareholders who traditionally don't have the upper hand should ideally know as much about the rights of majority shareholders as those shareholders themselves. I bet many of them don't know what their real rights are. That doesn't matter. Now, as Richards explains in the foreword, the book reverses the usual emphasis on the rights of minority shareholders to focus on majorities. Looking at this area, the lawyer says in terms of what the majority may do, the remarks he makes are the following. The book both emphasises that majorities have rights to and allows the reader to examine familiar principles and authorities, unfamiliar ones, of course, from a fresh angle as well. And I find that was quite helpful, because when you look at some of the case law that's mentioned, if you did, for instance, as a subject company law, say for undergraduate level studies, you will remember quite a large number of the cases at that time. And I think, if you are actually a student, this book would be worth reading if you are looking to get a fairly high mark, because it will give you a fairly good idea of the sort of problems that exist. And also, of course, one of the things is with examinations, the academic side, they do like the problem questions in company law, certainly at master's level. So this book could be a must for you if you are actually going as far as that. Now, back to the book. 4 barristers, all from Erskine Chambers, all of them expert in corporate law, corporate insolvency and related areas, have collaborated brilliantly, we say, and very usefully in the production of this well-established text, which is now published in a new second edition from OUP. They point out that while much comment in legal literature has been devoted to the rights of minority shareholders, literature on the rights of majorities has been a bit thin on the ground, so to speak, hence the requirement for a full-length legal text on this issue, which, being authoritative and reliable, combines the analytical with the practical. This updated edition then meets the needs admirably, certainly it does in our view, and as indicated, I think a lot of people will find it's not just people involved as shareholders, but people involved in the legal side of it will find this, I think, of great value. For example, rather than seeking to determine whether a minority might have a remedy for a particular grievance, the authors found it necessary to ask how far the majority could go before a minority could legitimately complain. Good point. We sought to identify the areas where majorities might come unstuck, they add, and sought further to provide some practical guidance. I think that's extremely helpful for anyone who feels that they're being put upon. Now, aimed at practitioners, of course, is what this book is about, and it provides practical advice over a broad spectrum of issues, from expropriation of minorities, beware of those drag-in provisions, and statutory squeeze-outs, to asset sales and to derivative claims. So quite complex. It's an area where you've got to have some knowledge about the way these people actually operate, so that you know how you might be able to combat some of the things that may actually damage you. The final chapter, as I said, deals with specific issues that arise in relation to the overseas jurisdictions. And I think that again is very helpful, because we are in much more in a global community today, and I think this is an area that should not be ignored. It's replete with commentary on the relevant cases, which I like. I think that's a very great help, and it serves to enhance the ability of majorities and their representatives to deal with the risks inherent in this area of law, and for the most part minimise the various challenges which can be brought by minority shareholders. So let me conclude by saying it's logically organised, extensively footnoted, and reassuringly succinct as a volume, providing an excellent source of references. As you would expect, it also contains tables of cases and of legislation, and every practitioner specialising in financial services we think should have a copy, and I'm sure most company secretaries in the bigger organisations will find this something they should have in their little library, basically. The publication date is cited at 2017. Let's have a look at the book again, just so you've got some idea of where we are with it. The introduction itself sets the scene, I think, very well indeed. There's the introduction again, just to remind you of what we've got. And it does actually highlight some of the newer cases that have come in, and the changes, looking at some of the cases they've cited here, the changes from what was basically the older law. Obviously Allen and Goldreese is one of the start-off points, if you like, but you can see how it's structured. Then if you run through the book, this is scope for a scheme to impose new obligations. This is looking at the nitty-gritty, schemes incorporating compulsory cancellation or transfer of shares. What I like is there are conclusions at the back of each of the main chapters. And then again, you've got this is asset sales. You've got you've got the standard short intro there and the little index, and then you've got all of the issues that you may well be looking for, depending on what your problem is, your issue may be. Dilution through capital issues. Again, you see you've got a major problem. It is about money, remember, always about money. Challenges to validity of resolution. Again, that's one of the reasons why your company secretary may find this helpful. Well, I'd like to thank the authors, David Chivers, Queen's Counsel, Ben Shaw, Ceri Bryant, I hope I pronounced your name correctly, Ceri Bryant, Queen's Counsel, and Chantelle Staynings. Thank you all very much indeed, and OUP, for producing this work. It's an important work. And as I've said, if you're an academic as well, it's worth reading too. Thank you anyway to all concerned. Bye-bye.